Factors referred to in section 60 sub 4A, read with section 60 sub 5. It is respectfully submitted that there is no likelihood in existence that I would, if I was to be released on bail, endanger the safety of the public or any particular person, or that I will commit a Schedule 1 offence. It is respectfully submitted that this would be a guide clearly taking into account the factors mentioned in section 60 sub 5 of the Act, namely, the charges as I foresee them do not involve the threat of violence made by anyone, and particularly not me. There is no proof that I harbour any resentment or will commit violence against any person. There is no acceptable and admissible evidence that I have previously committed an offence referred to in Schedule 1. In the premises, the factors mentioned in section 60 sub 4A, read with section 60 sub 5, are in my submission absent, and therefore there can be no likelihood that I will endanger the safety of the public at all. It is respectfully submitted that the factors to be taken into account as set out in section 60 sub B are simply not present here in either. I digress to indicate, as I am informed and verily believe, that this particular aspect deals with the primary consideration in bail application, namely whether or not I will stand my trial. I will deal with the main relevant factors in this respect. My emotional, family, community and occupational ties are all situated in KwaZulu-Natal, and in particular within the area of jurisdiction of this Honourable Court. My fiancée resides in Gauteng, which address has or was verified during my pending bail application as previously stated. I have no family residing outside the borders of the Republic of South Africa. I am self-employed in this regard. If I am to be incarcerated pending the finalisation of my trial, my business will be ruined, as it is a cash business. I am a public face and the driving force behind this business. Arrest and detention on its own, quite apart from the negative publicity which normally accompanies it, would ruin my business and ruin the livelihood of my employees and their families. My children attend school, and the school fees are paid by me from the income I generate from my business. I am able to afford an amount of 20,000 Rand for bail, and cannot be able to afford to forfeit this amount of bail, which may be set by this court. I record that if I'm refused bail, I would not be able to meet my monthly obligations. The minibuses I owned are subject to monthly installments from financial institutions. I respectfully submit that the strength of the state case against me is insignificant and is allegedly based on circumstantial evidence. I challenge the state in this regard to provide any eyewitnesses to my partaking in the killing of the deceased, and any objective evidence such as fingerprints lifted from an object or a place which may place me in a compromising position. The unlawful conduct of the members of the SAPS in forcing me to confess amounts to exceptional circumstances on its own. Their conduct amounts to a gross negation of my constitutional right. It also shows extreme malice on the part of the state, and such conduct profoundly affects the fairness of the investigation, progress, and any future trial. Surely such conduct cannot be the norm, and it is not then. If not, it is then an exception. It must therefore follow that it amounts to an exceptional circumstance on its very own. Factors mentioned in section 60 sub 4C, read with section 60 sub 7. I respectfully submit that there exists no likelihood that if I am released on bail, would attempt to influence or intimidate witnesses or conceal or destroy evidence. In this regard, it would appear that all exhibits the police to prove charges are in possession of the state, and therefore there's simply no way that I could conceal or interfere with or destroy any such exhibits. I do not know who the state witnesses are. I have not misled or attempted to mislead the SAPS or supplied any false information at the time of my arrest, nor have I given false information herein. In the premises, none of the factors mentioned in section 60 sub 4D, read with section 60 sub 8, militate against my release on bail at present. Even though all of the precise charges are known at this point in time, there is no proof that members of the local community or the media would have a sense of shock or outrage in this regard. I submit that there is no evidence that my release could cause shock or outrage in the community and would lead to public disorder. I will challenge the investigating officer and the state to prove cogent proof of such outrage, which is substantially more than simple mere hearsay evidence. My release would not undermine or jeopardize the public confidence of the criminal justice system. All that the public confidence required is that there is a proper, transparent and constitutional bail process. I believe with respect that the public only requires that the rules be followed and respects the court's judgment, and would be a sad day if something, or if sometimes unfounded and uninformed views of the public override the court's discretion. I have not caused any delays and will not cause any delay with the conclusion of the trial. In fact, those representing me would have preferred to go to trial. As a matter of urgency, once we've received disclosure of the state docket and have prepared on it, I need to be released on bail so that I can play an active role in the preparation of my defense. I challenge the state a motive as to why I would have wanted to kill the deceased. In conclusion, I respectfully request this honourable court to grant me bail as this court deems fit. In this regard, I am prepared to abide by reporting conditions. Finally, I respectfully submit that when one considers my personal circumstances, the conduct of the police, and the weak case against me, I have proved exceptional circumstances which, in the interests of justice, dictates leads to my granting of bail. The matter has been, or the affidavit has been signed by the accused. There is a confirmatory affidavit. Kusinde Ndemande, do hereby make oath and state I'm an adult male, I'm a South African citizen who's with identity number that, residing at Osilwane Reserve Empangeni, Tribal Authority. I am a Ward 13 councillor. The contents of this affidavit are within my personal knowledge and belief, unless the context indicates to the contrary, are both true and correct. I am duly authorised to depose to this affidavit and deal with those proceedings on behalf of the applicant. In my capacity as ward councillor, I am responsible for the day-to-day administration of the ward, including issuing proof of addresses to residents under the tribal authority. I've read the founding affidavit of the second applicant and confirm the contents thereof as far as they relate to matters concerning my ward. I can confirm the above-mentioned individual is a resident of my ward. For ease of reference, I append a copy of proof of address issued by my office, and that is annexed to the affidavit. That is the case for the second applicant, George.
You confirm the content of this statement, Mr. Ndemande? Statement accepted, handed in marked Exhibit D.
As concluded.
May I just find out from the court, Your Worship, I see that in paragraph the court can just bear. In paragraph 12 of the applicant's affidavit, there's reference to, I append a copy of the charge sheet annexed here in YY2. Does the court have it?
I do not have.
Because my copy does not have it.
No, I do not have.
And secondly, paragraph 36 of this Exhibit D, the applicant says, I own 4 minibus taxi. For ease of reference, I append a picture of minibuses. Just want to check if the court has the attachment there too.
There are no pictures attached.
And then lastly, the attached document on the last page. Just want to make sure that I have the same copy as the court. It says, I, Councillor Tula Kusinda Ndimande, ID number 8307025255, 085, to the authorized representative of Mfolozi local municipality in Ward 13, hereby confirms that. Is the name given in that?
And there are no names or ID number.
With ID number. Oh, okay. I just want to confirm if I've got the same with what my colleague was saying. I don't know then what they intend to do, whether this affidavit we should indicate that Exhibit YY2 and the photos of the taxis are not attached, or they want to attach same before we proceed.
Mr. Volmagans?
Thank you, Your Worship. This is clearly an oversight by those instructing me. May the matter stand down so that those copies can be obtained and handed to Your Worship.
Okay. How much time do you need?
Sorry, Your Worship.
How much time do you need?
How much time do you need? 10 minutes. About 10, 15 minutes, Your Worship.
10, 15 minutes. Okay, the time is now 20 past 11. The court will adjourn until 25 to 12. Court adjourns.
Yeah.
23/2156 of 2024. State versus Lindoguhle, Tabani Mkwanazi, and 4 others.
Thank you, Your Worship. Your Worship, I've now obtained a copy of the charge sheet and the photographs, etc., that are mentioned. May I hand that to the court, please?
The annexures Y2, annex copy of charge sheet case 23/11247 of 2023, and photos of the vehicles: NUZ 40792, BF92SGZN, BB48JPZN, and BF92 quotation.
I think that covers all the annexures, Your Worship.
I'm looking at BF92HGZN. There are 2 photos of one and the same vehicle.
Your Worship should have 4.
I've got 3 different
Oh.
vehicles. One is duplicated.
Sorry, which one is duplicated, Your Worship?
BF92HGZN.
Does Your Worship have BF28SP?
No,
Then that's the missing one, Your Worship. I do apologize. That will then conclude the application for applicant number 2.
do you have them as such, Mr. Kama?
I'm just trying to source one because there's also a duplication. It's BF28SP, I've got it now.
Okay. For the record, I have NUZ 40792, BB48JPZN, BF92HGZN, and BF28SPZN, 4 different vehicles. And YY2, the charge sheet, or copy of a charge sheet in case number 23/11247 of 2023. There's annexures to Exhibit D. And you say that is the case for
That's
applicant number 3,
Applicant
number 2. Thank you.
Your Worship, before I deal with the application for accused or applicant number 4, I understand that my learned friend for the state is going to bring an application for the exclusion of certain evidence which forms part of applicant 4's application. So perhaps we can hear what the nature is of the application by the state, and then we'll deal with it.
You indicated, Mr. Klaba, that there was going to be an objection to applicant number 4's papers.
Thank you, Worship. That is indeed what we highlighted earlier on. Your Worship, we were fortunate to be given a copy prior to the affidavit being read on record. What we then picked up is that On the affidavit by applicant number 4, there are certain documents that are attached. The first one being emails from
You wish to, before my learned friend proceeds, those emails have been removed from the application, so they do not form part of the application.
I raised an issue earlier on that there are documents. I'm now relating what I said earlier on about the documents.
Why you object?
Why I'm objecting. When you reply, when Mr. Vormanas replies, he can say, yes, I've removed this one, or whatever the case may be. I stood up and said, I have difficulty with certain documents attached to it. So now I'm given an opportunity to address the court on those documents.
I follow you.
There were email communications from Mr. Gaba, that is myself's email, official email, to Ms. Gilling. And some of my colleagues at work. Not relating to the accused before court. And therefore, there was no need for myself, as the person who was generating that email, to include any of my colleagues before court, meaning Mr. Tele and Mr. Dlamini and Mr. Mlodra and Mr. Volmarans, in that email. In the exchange between ourselves, I find my emails in accused number 4's papers, whereas he was not a party to that conversation, which is concerning. I'm asking myself how, for starters, did they manage to get hold of the emails between myself and Ms. Gillen? Not relating to this matter, yes, to the matter in Eswatini, but they were excluded because that email was specifically for Ms. Gillen. It's an official communication between two parties. Excluding others for reasons known to those parties who are party to the communication. And it was meant to be kept in that fashion. Hence, we were shocked when I saw that my emails form part of accused number 4's application. Before the matter started, I went to Mr. Volmarans and Mr. Tere to inform them this is a problem. Hence, Mr. Volmarans is now indicating that they've removed it. But it has to be placed on the record because I indicated earlier on my concern. The second difficulty relates to a charge sheet from another country, in particular the court of the District of Manzini, which is in Swaziland, or in the Kingdom of Eswatini. Purports to be the record of court proceedings in another country. My understanding is that Section 235 of the CPA indicates how court records can be presented in court. And it is jurisdictional in the sense that it applies in the Republic of South Africa. I'm here to understand as to on what basis a charge sheet or court record of another country forms part of these proceedings under which section. One might argue it is a public document. This particular court. We do not have it. What also bothers us more, on the very same document, there are notes written. Someone was working with this document, making notes of this document, indicating certain things on this document. More like, Your Worship, that my learned colleague, Mr. Twega, gives me an affidavit and say, please can you analyze this? Then I will make notes in that affidavit. So that when he gets it back, he can understand what changes he must do. It's like that. Now you are given notes of whoever thought you can attack this document because of A, B, and C, and it's given to you. The notes are not removed. The notes are there. From, I don't know how many pages are there, of an indication of how you should look at them in the critical eye of whoever made these documents. Or rather, whoever made these notes on this document. It does change materially the actual document that was handed in court. How would you tell, if the copy is not certified, that the document that is being handed in this court is the actual document that was handed in that court? Because this one now has got notes written on it. We don't know whether it's a magistrate who wrote on the paper or someone else, but from what I'm seeing, it appears that an attorney or whoever got this made reference to certain things in these documents, of which you should not have sight of that at all. But I'm still standing here not knowing who made the notes, because this charge sheet is not certified. It is on those bases that we are of the view that these cannot be admitted in this court. Unless there's anything else you wish. Oh, just a second. May I approach my colleague? I'm also reminded by my partner that the document itself, the charge sheet itself, does not relate to any of these accused. It relates to other persons in that court.
In that court of Eswatini.
Of Eswatini. This morning I indicated to Mr. Tele, you are attaching in accused number 2's application a copy of a charge sheet which you indicated is YY2. I said, please attach the entire charge sheet, because you are attaching a court record. You cannot attach a piecemeal of a court record. I was hoping he was going to do it, hence I am also standing to say we have indicated to him that we will attach the entire court record in our replying affidavit, because you only took a few pages of the charge sheet. It is the matter that we postponed earlier on this morning. The charge sheet thereof. Therefore, it is on this basis that we are saying the rules of admissibility, even though we are in a bail application, but it does not mean it's willy-nilly. Because you typify a document. I will make an example. With applicant number 2, the last document before the others were attached, it was typified or typified as a letter from the councillor, Mr. Tindimani. It's got letterheads and everything. Then you know what you're talking about. You saying I'm attaching and I'm saying this is a charge sheet. If this is a charge sheet, it then must follow the rules of how a charge sheet must be admitted in court. More so of a country that is not under the provisions of Section 235 of the CPA. On those bases, therefore, there are inadmissible portions of Mr. Kwabini's bail application affidavit, and we request that those be removed. My learned friend, Mr. Vollmerans, has indicated to me he has removed at least the emails referring to myself and Ms. Gilling, though we're still concerned about that, but we'll deal with it as the application goes on. Those will be my submissions, unless there's anything else that my worship wants to be addressed on.
No, there's nothing that I want to hear from you. My concern is, how did Mr. Vollmerans or Mr. Taylor get hold of the emails between yourself and Ms. Gilling?
I have no idea.
Thank you, Mr.
Thank you.
Mr. Vollmerans.
Thank you, Your Worship. As has been pointed out, those emails have been taken out of the application.
But what was the purpose thereof in the first place?
Your Worship,
Emails that pertain to other parties other than your client.
it pertains to a matter which my instructing attorney is the instructing attorney in the matter in Eswatini.
So how do they relate to this matter?
Your Worship, I can't explain that.
Yeah.
Now, Your Worship, none of those emails in any event are marked without prejudice, but I'm not going to take that any further. Your Worship, as far as the charge sheet is concerned, around Your Worship here are 7 TV cameras. And every one of the news houses that they represent, as well as the numerous other journalists present, all know about the charge sheet and probably have possession of it. It's a public document. Everybody knows about it. The minister makes reference to it. So the Commissioner of Police makes reference to it. Mr. Kele represents the two people in Swaziland. They provided him with copies thereof. So, and the application for their extradition relates to this matter, not to some other matter, relates to this matter. Therefore, Your Worship, there is or should be no problem unless the state has got something to hide.
Yeah, but what is the relevance of Eswatini charge sheet in these proceedings at this point in time when the people concerned in that charge sheet are not even before this court?
Your Worship, that record is relevant because we all know that those people are going to come back here. And once they are back, there's going to be an application for bail. And then the same old story about, well, why wasn't it mentioned before, is going to come up. We have a similar situation.
But Mr. Volmarans, with respect, I'm sure even if those people do come into South Africa and bring a bail application, it will not be before this court, in all probabilities.
Your Worship, the facts that have been given there relate to this matter. In any event, Your Worship, we're dealing with a bail application. The rules of evidence are somewhat relaxed. Hearsay evidence is allowed. So, Your Worship, there's another, my learned friend has referred to Section 235 of the Criminal Procedure Act, quite correctly. But there is an act which overrides that, and that is the accused right to challenge evidence. And he's introducing evidence which challenges evidence that is going to come. We know that. So, in terms of the constitution of this country, not Eswatini or anywhere else, we are saying it is relevant and therefore is admissible, because that is the criteria, is whether it's relevant or not. And we're saying it is relevant and therefore the court should allow it. If at the end of the day the court chooses to ignore it, that's the court's decision. But at this point in time, it should be allowed. This is a bail application. This is not a trial. And in any event, Your Worship, my learned friend has not given us any authority which says that a charge sheet from another country cannot be presented to a court in this country.
But should you not have laid basis first and foremost for presenting those documents?
We're not the ones objecting, Your Worship. If I object, I've got to lay the basis. If the state object, they must lay the basis, not me. I don't have to justify what the state wants to do. With regard to applicant number 2, my learned friend has made a lot of that the entire record hasn't been attached. But if you read his affidavit, he refers only to the charges that he is facing and attaches the charge sheet. He doesn't say, I'm attaching the entire record, because that matter cannot be placed before this court, and in any way influence this court because that matter is not yet finalized. So, Your Worship, it is my submission that there is no reason why the documents attached to the applicant's affidavit should not be allowed. Unless Your Worship wishes to hear me on some other aspect, those are my submissions.
In reply, Your Worship, this also complicates things further. Yesterday, I received an email from Ms. Gilling. After I have inquired from her, from our informal discussions, where I indicated to her, we do not know as the state in South Africa or the DPP's office in South Africa, in Durban in particular, as to who represent the two Eswatini people who have been arrested. I received an email with power of attorneys signed for Ms. Gilling saying I'm representing those two in Eswatini. Yesterday. Now I'm informed Mr. Tele is representing them, hence we got these documents. It baffles me more and more as we go along. But the difficulty about this document, Your Worship, is this one little thing. It purports to be a charge sheet from another country. It purports to be a court record from another country. The authority for the admission of a court record is Section 235 of the Criminal Procedure Act of South Africa. It's not even stamped, it's not even certified to say what it purports to be. It is what it purports to be. I made an example of the councillor. We have a letterhead that says this is the office of Councillor Ndibande. What are these documents? How do we know this is the charge sheet from Eswatini? If there's no back of the court stamp to say that, I can understand the submission that everybody here has got a copy. The media people have got a copy. I don't have a problem with that. Having a copy and submitting a copy for evidence are two different things. For purposes of these court proceedings, whatever you have, it must be relevant and it must at least, according to the rules of evidence, as relaxed as they are, the problem you are having is you are submitting what you term to be a charge sheet. And you want the court to put weight on it as being a court record. From where? We don't know. Anyone can type this first page. We're not hiding anything. The papers that the DPP sent to Eswatini, we know what we wrote in those. We're not hiding anything. All we're saying is, prove the documents in the manner that are supposed to be proved. Otherwise, if you can't, they cannot be accepted. It's as simple as that. Those will be our submissions.
They are challenging the evidence you're about to present.
I beg your
No, Mr. Volmaran's words, by the charge sheet, we are challenging the evidence the state is about to present.
How do they even know?
But those
How
were,
do they even know?
that was his submission.
Unless you can read from the crystal ball. For starters, just for starters, we might even choose not to lead an evidence. For starters, I do not understand on what basis can he make that submission. They haven't seen our papers. We have not even given them a draft. The understanding was, after the affidavits have been read on record, we will then reply. We're busy with our draft. Only that few of us knows what to contain there. He might anticipate what he thinks. And what makes it even worse, the papers that purpose to be in this charge sheet are not all the papers we sent to the court. For Mr. Volmaras to say it relates to this matter, it does not relate to this matter only, which makes it difficult now to bring evidence in a piecemeal fashion, because it does not give the proper picture that was given to Emanzini District Court. It was indicated right from the beginning, after the state has filed its affidavit, they will be given an opportunity to reply. Therefore, wait and see what has been filed and then respond, and not anticipate what you think is going to be filed. Because it might be different, you might be surprised. There might be anything at all. Therefore, wait. If you want to use this, in all fairness, follow the rules. Then you reply whatever you want to reply. It's irrelevant, as I said earlier on. Secondly, we don't know what this document is. Those are my submissions.
My ruling.
Oh, another aspect that Mr. Volmaras did not address, my apologies. There are notes here written on this document. It worries me. There are notes, and if the court sees that, I don't know what suggestion whoever wrote the notes wanted the person reading it to think of. The contents are typed, but they are handwritten notes in this very same document. I have no idea who wrote it, whether it's the magistrate who wrote it or somebody else wrote it, I don't know. Because there's a copy attached to this document where there are no handwritten notes. There's another copy attached where there are handwritten notes, which confuses me at all. As to what was the intention to submit and attach those papers that have no written hand notes, and also attach the same papers with written hand notes. I have no idea.
My ruling is that I refuse to see the charge sheet from Eswazini. They may be relevant, maybe, I say may be relevant, but I see no relevance at this point in time of a Eswatini charge sheet, and I refuse to see them. And moreover, I appeal to all the court officials to adhere to the rules of fair play. This is a bail application, I agree, but the rules of evidence are applicable, and I appeal that we adhere to the rules of evidence and commit ourselves to a fair play. Thank you.
Any court cases?
Thank you, Your Worship. Just in response to one thing, what my learned friend, first he said it wasn't relevant, now he says it is relevant to this case, but be that as it may, Your Worship. The affidavit, of course, has to be reworked in order to remove the charge sheet and the offending documents. So, and I notice, Your Worship, that it's already 20 to 1, and I've been informed, I don't know whether correctly or incorrectly, that the court is going to adjourn at 1 o'clock because there's no water in the building.
I don't know. Nobody has informed me.
My learned friend indicates that that is the case, Your Worship. So perhaps we can roll the matter until tomorrow as set down.
Is that the position?
And we were informed about the issue that there's no water in the building. I therefore take Mr. Wolmaran's submission that we roll the matter until tomorrow.
Mr.
And
Lord.
as the court pleases, you should know the record reflects that applicant number 5 was supposed to be also moving his application today in the light of the challenges that have been indicated, including, among others, the issue of the water in the building. I'm of the view that the same with applicant number 5, we can be able to proceed with this application tomorrow.
I want to place on record that I'm a little bit perturbed about the manner or the pace at which this bail application is proceeding. Bail application is supposed to be urgent, but with all respect due to the defense, there has been a delay of 2 days now due to unreadiness of the defense. I'm just placing that on record that it is disturbing on my part. But seeing that it is by agreement and due to circumstances beyond anybody's control, that the matter should be postponed until tomorrow, which was one of the days that it was set down for, the 18th, I therefore order that the matter shall then be postponed. Applicants may rise. Matter against you is rolled over until tomorrow, the 19th of March, for further evidence. You will all be kept in custody, Westville Correctional Institution.
They understand that?
Corrections until tomorrow.
Now